All right, you can put the Queen up too, are
I'm
you?
going to go off then. I'm going to go off video because I'm actually put makeup on.
Well, that's why I put it on, because I thought you looked pretty, and I thought that you had got pretty for the camera. Otherwise, I wasn't going to put it on. But then when I saw you got dressed up and looked pretty, then I thought that I would put it on for you, Diane.
Who are you talking to?
Diane.
Oh, sorry.
I saw that she'd got pretty because her hair's all done nicely, and and so
I just combed my hair. I had a haircut for the first time. Darling.
Yeah, everybody's got to be looking pretty because we're going to be famous.
I'm come out of the garden, so I'm looking atrocious.
Yeah, I'm not into pretty.
Neither. Just take me as I am.
I'm not into pretty either, but some people are. So
Kate, you know how you said that you're a 6164. All the baby boomers, all the people that are born like 1960, they'll all have like a 616, won't they?
Yes, and that was the time when they removed teaching of the 1688 and the Glorious Revolution and English history. They removed it from the schools at that time.
Yeah.
So we were the ones that grew up without it, and we've just stumbled back. So what we want to do is that we've stumbled onto a whole code system, but we don't want to be focused on that at the moment, because we've got to focus on the court, because we've got to have many discussions so that we can see what's going on. And we just have had this case come up today. What's this case that's come up today?
Is that the teachers one?
Yes.
The appeal for the teachers, yeah. I'm just going to put my camera off because I'm going to get changed.
Audio.
So, in this case, hang on, make sure that I've got the right ones first. This is the 24th of November. No. That's not the one we want, is it?
Is it the one that you had earlier? You were talking about earlier?
Yeah. Here it is, 8th of April. Right, I'm going to go to share screen. And the judge, right, can everyone see my screen?
Right.
I've shared it.
I can.
I'm just to open the recent court ruling that has come out on the 8th of April, 2022, where the evil people, the United Nations, and the common law people, NZDOSOS, who I do not trust, and I'm not ashamed to say, the NZTSOS, which is all United Nations backed. And we know that they're trying to get the 1990 Bill of Not Rights entrenched with all of these sneaky things. Now, our question is, the question that we're asking is, which law is going to be the highest law? The 1688 Bill of Rights under God Almighty, or the 1990 watered down ordinary law that has no constitutional power? And what they've been trying to do, these sneaky sods, is to give the 1990 constitutional power and they're trying to deceive the people that it has constitutional power when in fact it doesn't. And you've all been deceived. And I'm not going to read all of it. Anyone can read, but you've only got to go down as I've said in the 1688 Bill of Rights, you've only got to go down to section 48, and it says here, so that I'll get my 1688 Bill of Rights under God's law. When the man comes to town, the highest law is actually the 1688 Bill of Rights. And under the 1688 Bill of Rights, this one's is in a thing, it's in New Zealand Acts, but you will see here, it's got here, hang on, cruel and unusual punishment. Hang on, I have to get that for you. You will see here, hang on, no dispensing of power, subjects' arms. Oh, it comes under the excessive. No cruel and unusual punishments are to be inflicted. Now, under the 1990 Bill of Rights watered down law, they have got S5, Section 5, justified limitations. And in this case, they used Section 11, the right to not be forced to take vaccinations and medical experiments. And the COVID response used Section 5, and they said we have a justified limitations. And I have been saying that under the 1688 Bill of Rights, it would come under cruel and unusual punishment being inflicted to force you to have an injection, a sharp pointed object put into your body, a sharp pointed object put into your body with substances in it that you didn't know what they were. That could come under cruel and unusual punishment to be inflicted upon your individual person. You see, all their laws are written as the collective, but these are your individual rights under God. And this is where you need to go for your power, is your individual rights under God. And they are protected. And so the judge has said it right here. He said, the New Zealand separated out the right from other associated rights when they enacted the Bill of Rights. As Pankos indicated, all means all. New Zealand thereby charted its own path in separating out a right to refuse medical treatment. So New Zealand chose to use they're choosing to use tikanga law under the Maori, and New Zealand is choosing by their own choice, by your own choice, to use the 1990 Bill of Rights. You can use it if you want to be stupid enough to use it. But if you don't want to, you don't have to. And it says that you have chosen that path to use the 1990 to refuse medical treatment, but they have put a justified limitations in there. So as New Zealanders, you don't have to use it, because here you can go down and look more that in other human rights instruments, this right is subsumed within other more generally expressed rights. So it is a general law that is not absolute. But in so doing, the Bill of Rights, which they don't tell you which one, but you can see here they're talking about the 1688 Bill of Rights, where it says the Bill of Rights distinguishes this right from the right not to be deprived of life, which comes under S8, the right not to be a subject to torture or cruel treatment in S9, and the right not to be subjected to medical or scientific experiment in Section 10. Now, here he's gone a little bit sneaky. because he is attached 2 to 1 paragraph, and this is what I'm trying to get them to stop doing. He's used S8 of the 1688 Bill of Rights, the right not to be subjected to torture or cruel or unusual punishment. And then he's put in S9 of the 1990 Bill of Rights, the right not to be subjected to medical or scientific experimentation in S10. So it looks like he has combined. However, then he's gone on to say SS 8 to 10 can be seen as more absolute in character, as the Supreme Court has reiterated. So this is a little bit, I would be questioning in this as the judge, because he's doing a mixy-moxy of the two laws here and saying absolute character. So if we, the problem with the 1688 Bill of Rights is it doesn't give sections, and it can be often confusing of which one is S8 and which one is S9 and which one is section anything, because it doesn't use sections. So it can be very ambiguous. And then when they mix and match it with the 1990, which does have sections, it's very easy for them to enact deceptions here. And we're clearly going to the court to ask them which one is absolute. But I think that whenever they've used the cruel and unusual, that can be seen as an absolute in character. But he says, but although, and he's done a mixy-matchy there, which was very confusing, which we will be addressing that in the court. But although the right in S11 can be seen as belonging to the same family of rights, so he's putting them into the family. Yes, you can see where these people are going with this.
Yeah.
You know, trying to put it into the family. It's separation out from the other rights, particularly the right to be free from medical or scientific experiment in S10 has significance when proposing a separate right in what was to become S11 of the author's white paper. Now, you're all going to be saying to me, what is the white paper? The white paper is when Geoffrey Palmer and his cronies proposed the 1990 New Zealand Bill of Rights. And when they proposed it to be the supreme law, they originally proposed it to be the supreme law. It was turned down as a supreme law because it had no restrictions on Parliament and no restrictions on anyone, which is why they wanted it in the first place. It had no restrictions on the Maori king. It had no restrictions on tikanga law. It had no restrictions on anybody. But the 1688 Bill of Rights has restrictions on the Pope, the Queen, the Parliament, the police, the ministers, the whole caboodle is in the 1688. So because of that, the 1990 Bill of Rights was given the status as an ordinary law to be used as the machine for the United Nations to attach on all of their laws with the justified limitations, whereas the 1688 continues to be a supreme law and it should not really have things attached onto it, actually. And so there's a lot in section 48 that we need to go and study. You need to go back and study the white paper. And so then, and what this judge has done, where he's used the supreme law and then he's gone and used S9, S10 as the 1990 and attached it on. And then there's some confusion where he says 8 to 10 can be seen as absolute in character. But the question is, could Section 9 of the 1990 Bill of Rights and Section 10 of the 1990 Bill of Rights, could they be seen as an absolute character by themselves as being absolute if they didn't have Section 8 of cruel and unusual punishment to sit on?
True.
Could they stand alone? And I'm saying no.
No.
So I'm saying that it's time that the courts and the parliament admitted that their 1990 only has power if it is sitting on the shoulders of the 1688. And there, as Sharon says, the 1688 only has power as long as it's sitting on the shoulders of who, Sharon?
The Māori.
Yes.
Oh, God.
No, we're not up to God yet. We're up to the Queen, sitting on the Queen. But actually, yes, the Maori also. Now, why, Sharon,
Yes.
you're thinking to yourself, why did Sharon say the New Zealand Maori? And here's why. In 1865, for the first time in more than 200 years, the New Zealand Maori went to the court and declared themselves under the protections of Her Majesty the Queen under God. So all New Zealand law is rested on the New Zealand Maori of 1865, which is correct. And then to go further, Sharon, where did we go next? Was we went to that then rests on Her Majesty the Queen. And Sharon was also correct. Where does it go further? That rests in that she is bound under God. She is only an instrument. She isn't God. She is the instrument of Almighty God to make sure that our individual rights are not trampled on while they go around making all of the collective rights.
Yep.
So that's what this is all about. So this is what I'm trying to make clear to all the New Zealand public, is that your 1990 only has a power if it is able to be rested on the 1688. Therefore, your 1688 is your true and indubitable right. And that is where you ultimately, if you're having problems with government, you're having problems with parliament, you're having problems with all their subordinate laws, ultimately you need to go to your supreme law for your protection. And the New Zealand Maori knew that. They realised that. In 1865, they realised that they could not win. They weren't winning in the courts, and they realised that there was a supreme power that they could go in. Because they well understood about God and their spirituality, they knew that they could go to the God to get what they needed, and that's what they did, and that is serving us today. Two more 100 years later. And that's why we're going to the court, because we want to serve our descendants many hundreds of years in the future. All right, are you still there, Diane?
Yeah, I'm still, yeah.
All right,
listening,
are you
yeah.
dressed? All right, there you are.
I'm dressed, but we're going away, so we just.
We're finishing because I've got to go out. We're going to finish.
We're going away.
No, that was the only piece I wanted everybody to talk about today. Just the last bit. Then he goes on to say, right, we've got, can we do 4 more minutes and we're gone? This provision has no equivalent. He's saying, this provision has no equivalent in the International Covenant, nor any other international human rights instrument. It enacts as a general principle that everyone has a right. He's saying it's a general principle. Everyone has a right to undergo any medical treatment. This right, of course, is subject to Article 3 of whatever, I don't know, but it has anticipated that this would permit persons to be treated against their will only where this is necessary to protect the health and safety of persons, and not simply where there is a refusal of treatment will detrimentally affect their own health. Now, read that carefully.
Yeah.
He's saying that if it's going to be detrimentally affecting your own health, then under the 1688, that comes under a cruel torture. But that there is also a course of action in their 1990 and in their laws that if they're not refusing is going to hurt other people, that there is a place there, but theirs is not equivalent to ours. So we've only got to...
And can I just say, Kate, that
Yes.
when the 1990 was made, it never came back to Māori to have an input in it either. It wasn't mandated by Māori.
We are going to... Sharon has just raised one of the most important questions, the important things. I'm not going to do it in this video because it's going to take me half an hour to explain it. But I want you to... That thing that you've just mentioned there is extremely important. Did the New Zealand Maori approve, and did they have any input? And Sharon, I'm going to tell you, actually they did. And I'm going to... Yes.
Really?
Yes, there's actually, and I'm going to show you that the New Zealand Maori said no. And they were overridden 3 years later behind their backs.
Mhm.
And
Okay.
Sharon, I'm not going to do it in this video because we've got to go through 3 laws to show you how that happened. And I've put that in my court case. Yes, I have addressed it. And they said no. And I'll show you why. So we always, we've got 1 more minute here. Does anybody want to have anything to say before we go? No. So this is the main point that we've been addressing today. And we're going to finish up this one today. And I am going to be posting this. And we're going to remind me when we come back for the next video that we're going to address that issue. So that exact question that you said there, Sharon, I would like you to, if you don't mind, write it down and please bring it up in the next session, and we will start our next video exactly there where you are.
Thank you. Okay.
And I'll bring it for the preparation. Very, very excellent. What am I looking for? Observation there, Sharon. A very excellent observation that Sharon has made. All right, we're going to see everybody later. I'll be posting this. See you later. We need a group name. What are we going to call our posts? All right, Maori Pian talking about the law. Okay, see you later.
Bye.
Okay.
Hi, thanks,
Bye.
Kate.